All right, good morning. I'm Paul Peterson. I'm the director of the program on education policy and governance at Harvard University, and I'm a senior fellow at the Hoover Institution. And I want to welcome you all today to an event that celebrates the publication of a new book called Scalia's Constitution, Essays on Law and Education. It's published by Paul Gray Macmillan, and the editors are myself and Michael McConnell, who is a professor at Stanford University School of Law and was a judge of the Circuit Court of Appeals. So we held a conference about a year ago in which all the papers that were gathered together for this short publication were discussed and analyzed, and we have with us today two of the participants in that conference and authors of two of the essays included in this collection. Antonin Scalia was an Associate Justice of the United States Supreme Court who wrote and signed opinions that bore directly upon fundamental elements of the American educational system. He was also a scholar and a leading public figure. It's appropriate then to honor this man with a collection of reflections on his impact on education, seen broadly as not just schools, but scholarship and public discourse as well. In doing so, we hope to discover, through the education window, a look into the fundamentals of the justice's thinking. Now, few doubt Scalia's impact on constitutional jurisprudence. Cass Sunstein at Harvard says he was not only one of the most important justices in the nation's history, he was also among the best. And Justice Elena Kagan says, part of his greatness consists in his abiding commitments, above all, to the rule of law. His articulation of textualist and originalist principles communicated in that distinctive, splendid prose transformed our legal culture. Despite this applause and despite nearly 30 years of service on the Supreme Court, only a few have sympathetically considered Scalia's constitutional approach to judicial interpretation. His powerful, prolific writings are partly to blame. Author of several books and numerous lectures, Scalia was able to defend his position so skillfully his disciples seem to have held back. As a result, most book-length assessments of Scalia's life and work are critical. We offer in this collection of writings the hope that it will go some ways towards balancing the current Scaliana and encourage others to add their own contributions. But though this is a sympathetic interpretation of the justice's contributions, it's no eulogy. The collection includes an essay by a strong proponent of the living Constitution, and others identify tensions and limitations in Scalia's thought. Education may be thought to be an odd entry point into Scalia's thinking, but basic constitutional questions, free exercise of religion, freedom of speech, equal opportunity, due process of law, federalism, and the role of the expert all arise when considering the institutions that prepare a country's next generation. To appreciate Scalia's Constitution, it's necessary to place it in historical context. And so in my opening essay, at the risk of great oversimplification, I divide the history of constitutional interpretation into four broad historical periods. The first, which I call naive originalism, lasted for more than a century. During that period, justices simply and without apology interpreted laws as constitutional or not by looking at how they compared to the document itself. But at the beginning of the 20th century and well into it, this perspective comes under increasing attack from judicial realists who say that it is not, this line of interpretation is nothing but a mask for capitalist dominance in American life. And they said that instead of the justices exercising the power of judicial review, they should defer to the will of the majority. And that realist view comes to dominate court thinking during the New Deal And the switch in time that saves 9 is thought to be a critical moment when the court begins to back away from declaring laws of Congress and the states unconstitutional because they don't fit with what some think is the correct understanding of the Constitution. So judicial deference to legislative majorities is the dominant view in the post-war period until the 1960s, when, in the wake of the Brown decision, the court moves in the direction of interpreting the Constitution as a living document, one that can change with the experiences of the American people as interpreted by the justices themselves. And so this new line of thinking, which establishes the court as a definitive interpreter of the Constitution, but now an unconstrained court, one where justices can express their own perspective on the issues of the day, is the one that Scalia is troubled by. And to counter that living Constitution doctrine, he constructs what I would call a new rugged originalism, one that pays close attention to the text of the Constitution and the meaning of that text as originally understood by the people who read it. Not the original intentions of those who wrote it, but the meaning of the text as originally understood. And he combines that with a respect for judicial precedent and takes into account the judicial realist critique of excessive, of not accommodating to the will of the majority as expressed in legislative enactments. So this new originalism has a ruggedness that's able to stand up to and perhaps usher into a new period that will provide the court with some alternative to the living Constitution doctrine that has held sway for such a sustained period of our contemporary history. Well, that's my overarching perspective. The members of our panel today are going to elaborate their own perspectives as it applies to specific domains of this question. What is Scalia's Constitution as it pertains to education? And I'll introduce all of them now so that we can move quickly through the panel. The first speaker will be Shep Melnick, who's the Thomas P. O'Neill Professor of American Politics at Boston College. His research and writing focuses on the intersection of law and politics. He's written several books and many articles, but the one that I think is most pertinent to mention today is the forthcoming book that Brookings will be publishing early next year, entitled The Transformation of Title IX, Regulating Gender Equity in Education. I'm sure you will find it very pertinent to the contemporary debates over the meaning of that piece of legislation. Our second speaker will be Amy Wax, who's the Robert Mundheim Professor of Law at the University of Pennsylvania Law School. She holds degrees from Yale, Harvard, and Columbia. She served as a law clerk to Judge Abner Mikva on the D.C. Circuit Court of Appeals. Abner Mikva was my representative to Congress when I lived in Chicago, so, you know, I think he was a terrific individual at that time, and I'm sure that was a great opportunity for Amy to hone her skills as a legal analyst. And then she worked in the office of the Solicitor General at the Department of Justice. And finally, we have, as a commentator on the enterprise, Ambassador Boyden Gray, who is the founding partner of Boyden Gray and Associates, a law and strategy firm in Washington, D.C., who has for many years focused on constitutional and regulatory issues. He was the White House counsel to President George H.W. Bush. He has served in many other positions in government and was the ambassador to the European Union. He, I must add, was the editor-in-chief of the Law Review at the University of North Carolina, and after serving in the Marine Corps, he clerked for Earl Warren, Chief Justice of the United States Supreme Court, and the man who had much to do with the construction of the living Constitution. So it'll be great to have all of these perspectives this morning, and we'll try to ask everybody to keep their comments limited to 15 minutes or so that we will have time for discussion. Shep Melnick.
When Paul first asked me to contribute to this volume, I was a little bemused because I thought it would be like writing a commentary on the barking of a dog that didn't bark. And by that I mean that Justice Scalia didn't write a lot about his education philosophy or his theory of law and education. So I constructed this short summary of what I thought Justice Scalia would say about his views on law and education. And this is my made-up quote. I don't have much to say about law and education. To the extent I have coherent views on education, they influence where I send my children to school and how I vote in the voting booth. But not much to say about what I do as a judge. Unlike state constitutions, the U.S. Constitution doesn't even contain the word education. Public schools are no different from any other public institution. They cannot discriminate on the basis of race. They can't establish a religion, and they can't discriminate against religion. To be sure, many federal statutes govern educational institutions, but my job as a judge is to read and apply the text of the law, not allow my personal views on education to come in through the back door of speculation about claims of statutory purpose or legislative history or intent. The method I employ to interpret the Constitution and federal laws contains no special provision for educational institutions, and they shouldn't. For that would suggest that I know more about education than school boards, legislators, governors, and school administrators. I don't, and judges should realize as they don't. Now, this is obviously quite different from many of his more liberal colleagues, because for many liberals on the court, the job of the judge is to promote equal educational opportunity. And that is what Justice Breyer called not the words of Brown, but the hope and promise of Brown. And in order to do that, they need the help of a lot of experts, and that is what Amy Wax will be talking about Justice Scalia's distrust of educational experts, or basically experts talking about abstractions in a variety of contexts. And Justice Scalia's view was that what Brown versus Board of Education culminated in was a very simple rule, not a broad quest for the promise and the hope of Brown, but the rule that our Constitution is colorblind and that racial classifications are so pernicious they should be used only in the most limited circumstances. The purpose of the court's rulings on Brown and its successors is not to produce the best possible education, but to prevent the worst possible abuses, and that is the use of racial classifications. Now, during the conference, Paul tried to provoke some controversy, and he knew that Amy Wax would never say anything controversial. So he tried to provoke an argument between the dean of the Harvard Law School, Jim Ryan, and myself, in which he succeeded in doing, and it resulted in an article in Education Next, I think has been handed out. And this was, I think, a useful debate. And here's what Jim Ryan's argument was. It's something you've probably heard before, but I think he stated it forcefully, and it requires some response. His argument, especially about Justice Scalia's view that affirmative action programs at the University of Texas or in the parents involved cases were unconstitutional. His argument goes, Ryan's argument said, number one, this view of the colorblind Constitution is not in the text of the Constitution. It's not in any original intent of the framers of the 14th Amendment. It disregards precedent. It overturns the decision of state and local decision makers. So to the extent that Justice Scalia insists upon taking this view, he's contradicting everything he claims to stand for, and that this is pure policy making of the sort that Justice Scalia condemned others for doing. Now, What I would like, the way I'd respond to that, and I think this goes to a really fundamental part of Justice Scalia's jurisprudence, is to understand that Justice Scalia didn't claim that there was going to be one way of determining whether a law was constitutional or unconstitutional, but rather that there were a variety of considerations that needed to be taken into account. Now, to some extent, that makes it hard to say that the rule of law is the rule of law of rules, because it requires some consideration. But what of these balancing and looking at these hard cases, but what were these series of considerations that were particularly important to him? First and most important, obviously, was the text of the Constitution, and as Paul said, its original meaning. But Justice Scalia presented his view as text and tradition, not just text, which means well-established precedents have to be respected. And this means, above all, I think the most important of these is Brown versus Board of Education. No matter whether Brown versus Board of Education can be squared easily with the text and the original understanding, it is so well entrenched, and deservedly well entrenched, that has to be one of our starting points. On top of this, respect for elected officials, the people who write the laws whose text we should respect, and that's true of Congress and state and local officials. Farther down the list, deference to administrative agencies. If you don't believe that judges have the expertise, you look to other experts. And finally, and I think in general, appreciation for the limited competence and capacity of judges. Now, as I said, Brown creates a hard case for a textualist. Justice Scalia really didn't say a lot about the grounding of Brown. One of the co-authors, Michael McConnell, has tried to show that there was support among those people who authored and voted for the 14th Amendment to prohibit use of racial classifications and segregation. That's one part. But what Justice Scalia basically said when he did talk about it was that there is this long tradition of understanding the Constitution as colorblind, stretching from what Professor McConnell found in the authors of the 14th Amendment to Justice Harlan's famous dissent, to the views of the NAACP, who argued Brown versus Board of Education, who clearly supported this view. Often forgotten, and I think is particularly important, is what the Civil Rights Act of 1964 says. Clearly, that they say that that racial discrimination of any sort is forbidden, even if it is used to achieve racial balance. And finally, a wide variety of court decisions on suspect classifications. And I think behind this lies an understanding, which I clearly share, about the unique evil of racial classifications, especially in a system such as ours that relies on Madisonian pluralism to govern. Now, in trying to deal with the legacy of Brown, Justice Scalia tried to limit some of the expansion that threw up through the precedents followed Brown, especially, I just use the leading example here, which is the Swan case of 1971, which both Dean Ryan and Justice Breyer basically take really as the cornerstone of their analysis. And if any of you know anything about the Swan case, it is probably the most baffling, confusing, self-contradictory decision ever written by the Supreme Court, and I think that's saying a lot. What Justice, in a nutshell, what I would say is that Justice Scalia was, in trying to kind of prune back some of these precedents to get to what he viewed as the heart of Brown versus Board of Education, was above all saying that these decisions that were used to deal with the extraordinary problem of Southern school desegregation, which was the extraordinary opposition, and the court and the government in general had to take extraordinary measures to defeat that, that those should not be applied in ordinary circumstances, that we should try to revert to what he called the ordinary method of statutory and constitutional interpretation. Now, I thought I would mention something about another problem that Justice Scalia wrestled with, and that is cases in which civil rights are established under civil rights statutes and especially under the regulations issued by administrative agencies. I was thinking about this. I've been working about Title IX endlessly for the last couple of years. And some of you might know that at the beginning of the year, the Supreme Court had on its docket a case called the GG case about the access of transgender students to bathrooms. And the Office of Civil Rights in the Department of Education had issued a letter basically saying that schools had to respect the gender identity of students in allowing access to gender-segregated facilities. The Fourth Circuit had upheld that. The Supreme Court decided to review it until the Trump administration withdrew the letter and the Supreme Court sent it back to the Fourth Circuit. Now, I must say that I really would have liked to read Justice Scalia's opinion in this case. It would have been an opportunity for him to write one of his probably most vivid and witty and memorable decisions. But he didn't get that opportunity. What I would point out is there's an irony here. Because I'm sure that Justice Scalia would not have upheld the Fourth Circuit, but there are two of the most important precedents that have been cited by the courts in those cases. One was Justice Scalia voted with the majority, and the other, he wrote the opinion, and that was the Oncology case. I hope I pronounced that right, but I won't go into details. But Justice Scalia wrote that the sweep of Title IX, and especially its sexual harassment rules, is not limited to what legislators had in mind at the time. And Justice Scalia has also at various times been an advocate of deference to administrative agencies, including their interpretation of their own regulations. This is a problem in which he tried to be loyal to legislative enactments, in which he tried to recognize administrative expertise. But I think it has increasingly led to a situation where he would be appalled by the outcomes, and which often, especially in rules about affirmative action, he would have to decide whether this violated the Constitution. In many cases, I think he probably would say yes. So what I'd like to leave with this thought, which is that Justice Scalia's understanding gives us a number of different serious concerns about how we should govern ourselves. But it leaves us with the difficulty of trying to bring some order to these important concerns when, as is often the case, they conflict. And I think that that's going to be probably the most important job of the people who consider themselves to be followers of Justice Scalia. Probably a lot of folks will be on the new justice of the Supreme Court, and how we can square what I say our doubts about judicial capacity, our concern for constraining the court's ability to read whatever they want into the Equal Protection Clause, our respect for the democratic process, and these things sometimes conflict. And that, I think, is the job that all of us face in trying to carry on his legacy.
Thank you, Shep. Amy Wax.
Okay. Thank you for having me, and I'm very glad to be here. In the paper, the chapter in which I base this talk, I address the role of expertise, the use of specialized knowledge and methodology in Justice Scalia's opinions, and especially his education decisions, but others too. And here's some of what I'm going to be saying or reporting about Justice Scalia might be in tension with some of what Shep has said, which I think shows that Justice Scalia is not always consistent in the way that he treats expertise. And here I'm referring specifically to his philosophy of deference to administrative agencies. So I think that it's very important to keep that in mind, and I go into a little more detail in my chapter. Now, what forms of expertise do I mean here? Well, there are really two main types that figure in his opinions and loom large in modern contexts and in our current political moment. The first is scientific, including social scientific, that is the systematic study of social life and relations and human behavior, using scientific methods. This is familiar to us through the fields of psychology, economics, sociology, and of course includes research on education and the development of so-called human capital. The second body of expertise is legal. The rules, laws, principles, and especially the analytic methodologies by which lawyers are schooled and in which they are schooled, and about which they purportedly possess superior skill. They make claims to expertise in this area. My paper explains that Scalia's stance towards expertise generally and social scientific and legal expertise specifically ranges from cautiously skeptical to dismissive. And I seek to connect that attitude to important elements in conservative thought. Ab initio, it's important to note that conservatives, of course not a monolith, encompassing various schools of thought, are not hostile to science or specialized skill where appropriately applied. Rather, they are suspicious of what philosopher Anthony Quinton calls the epistemologically pretentious forms of expertise. Conservative intellectuals seek not just to confine exertions of expert authority to their proper spheres, but also to discredit overdrawn claims of superior knowledge and insight that they believe are easily subject to abuse. In a nutshell, conservatives look askance at experts' attempts to manage, govern, and shape social life based on claims of superior insight into human nature and behavior. Too often, supposed experts can claim no more authority, wisdom, or genuine knowledge than ordinary people. Conservative critiques of expertise are inevitably tied up with an attitude towards elites. Conservatives aren't anti-elitist, in fact, quite the opposite. They just have a particular conception of how elites should be selected and elevated and their proper role in society, which is, to sum it up succinctly, if somewhat simplistically, right, they should serve mainly as a stabilizing and preservative force, or at least as cautious agents of change, and should not function as meddlesome, disruptive social engineers seeking to transform existing arrangements in accordance with their theoretical commitments and, in many cases, their political views. So what is the source of the conservative beef with expertise? Before I get to Scalia's opinions on this, I want to just elaborate a little bit. Well, many are wary of the ability of rationalized systems of knowledge generally, and especially in the human sciences, to fully explain and to effectively inform the management, reform, and improvement of the human condition. For many, these so-called improvements don't end up improving. As often as not, they destabilize or destroy what deserves to be preserved, including some long-standing traditional arrangements, with costs too often imposed on those least able to bear them. Here it's good to be reminded of the trenchant observations of the great 20th century social theorist Albert O. Hirschman, no conservative himself, who said that conservative arguments generally come in three varieties. Arguments from futility, a proposed improvement won't work; from jeopardy, they will destroy something valuable; and from perversity, whatever is proposed will have unintended or opposite consequences to those hoped for. All these are made by conservatives, all these claims, against the pretentious application of expertise. And in this vein, it's worth elaborating a bit more on the cluster of insights that stand behind the conservative skepticism. First, a robust sense of the limits of human reason and understanding, an acknowledgement of the stubborn infirmities of human nature, the crooked timber of humanity, which resists drastic manipulation and perfectionism, a hostility towards an expansive centralized administrative state as a means for experts to shape behavior and institutions, an antipathy towards the rise at the helm of this sprawling administrative state of an elite managerial class eager to push their vision of social life and unlimited human potential on the rest of us, a skepticism towards elites' claims to operate on the basis of objective, neutral, scientifically informed methods, independent of ideology that helps legitimate their authority. And finally, objections to expert elites' hostility to, indeed at times disdain for, traditional, decentralized, ad hoc, informal, irrational, prejudiced approaches to social life and norms, including some long-standing practices and approaches in matters of education, of character formation, of upbringing, and of family life. In my paper, I review a sampling of prominent thinkers who put forward these views. These include Frederick Hayek, Michael Oakeshott, Alistair MacIntyre, James Burnham, Richard Weaver, Stephen Hayward, thinkers that my students, at least, have never heard of. Because time is short, I will just touch on one example. Alistair MacIntyre, in his book After Virtue, explains his grave doubts about the government's and modern bureaucracy's ability to manage and govern social life, as is familiar with what I just said, on claims of superior insights. Once again, although recognizing a role for science, he denies that the scientific method can gain insights into ordinary human behavior in politics, in social relations, even in economics, due to, quote, the sheer complexity of human behavior and social life and its moral dimension, which resists and eludes law-like generalization and prediction. And he adds that denying this unruliness leads to abuses of authority by these so-called experts under the guise of scientific impartiality. Now, in the final part of my chapter, I identify and explore Scalia's articulation of some of these themes, skepticism about expertise, not only in the treatment of social science, but also as applied to the important realm of jurist activities, to interpreting and analyzing the law as embodied in the process of judicial analysis and decision-making. After all, he is a jurist. In fact, Scalia frequently identifies the findings and legal principles that purport to support judicial decisions as lacking in determinacy, impartiality, and the objectivity which he says is claimed for them. And I think this resonates to this whole living constitution issue, by lawyers and judges under the banner of their methodological expertise. And he often defends traditional and customary understandings and ordinary people's practices and preferences against attempts to override them under the guise of the even-handed application of legal analysis and legal principles. Finally, he depicts, for better or worse, much of the federal judiciary as a like-minded elite expert class that buys into a progressive vision of society and uses claims of expertise and objectivity as a cover for smuggling in their preferred political and policy choices. These expressions, the expression of these ideas are not hard to find in the education cases and in other areas. I have a host of examples in my chapter, certainly not exhaustive, but I'm just going to touch on two very briefly here. In the education area, there is Scalia's dissent in Grutter v. Bollinger, the case in which the court upheld the use of affirmative action in law school admissions at the University of Michigan. Justice O'Connor, writing in support of that, states that educational administrators and professors deserve deference on their expert professional judgment, that racial diversity is vital to the law school's mission and pedagogical effectiveness, and that racial preferences are absolutely necessary to deliver these benefits. In his dissent, Justice Scalia takes issue with that. He denies that university officials deserve deference as specialized expert endowed with superior insights into how best to educate law students. He cast aspersions on what he viewed as empirically unsupported claims that law students would benefit from this engineered diversity and become better lawyers as a result. And he faults law school authorities, the experts, for assuming once again without credible evidence that these supposed lessons from diversity, which he views as just basic lessons in citizenship, could be effectively or most effectively transmitted at the law school level rather than by, for example, by traditional modes of culture transmission and inculcation through the family or religious institutions, civic organizations, the Boy Scouts, other avenues, and the like. In a second education case, Freeman v. Pitts, Scalia casts aspersions on the exercise of expertise in the context of interpreting the Constitution as applied to school desegregation. There, the court remanded a long-standing desegregation order to determine if the school district at issue should be relieved of court supervision. One issue, the key issue in the case, was how much remaining actual segregation in the district was traceable to past legal segregation and therefore remained to be legally corrected, and how much was not. Scalia's concurrence in specifically addressing this offers a general critique of the court's empirical methodology in desegregation cases. He observes that the court has never developed a reliable and precise formula for determining whether the imbalances in student assignment can be traced to past official actions as opposed to, quote, attributable to private demographic shifts, that is, private action, which is not correctable. And he expresses doubt that the judges are equipped to make these highly sophisticated determinations, especially as official segregation recedes into the past. The consequences of this failure and the rhetoric accompanying it, suggests Scalia, is an arbitrary exertion of power to bring about the result judges regard as best for society without any sound justification. Because their analysis is so shaky, he says, the court's decision is just a cover for the judge's preferred policy outcomes, which is more court-ordered supervision, more court-ordered integration. Now, in closing, right, I want to say that, as noted, one theme tying these cases together, and one that is found frequently in Scalia's opinion, is that lawyers and judges' indeterminate, open-ended methods, often under the guise of or pretension of determinate methods, leaves room for result-oriented judging. Now, of course, this assertion raises a host of methodological questions, serious questions, I think, not addressed in my paper. Is there a more determinate, impartial alternative for judicial decision-making that would eliminate or at least reduce this problem? Obviously, Scalia had something to say about that. His work on originalism, for example, and many have questioned his analysis. So I leave you with a very hard problem. Exactly how should judging and legal analysis itself be reformed to avoid or solve this problem? Is that even possible? Or is the reign of legal elites in government and society generally, with their biases, their preferences, their leanings, an inevitable feature of our political system, which must to that extent be partisan? Is there some way to reduce their influence, and would we really want to? What does the reign of elites mean for our political present and our future? Those are the questions that I leave you with. Thank you.
Thank you, Amy Wax. Ambassador Gray, you have a chance to illuminate the manuscript as a whole. We look forward to your comments.
This might be a wee bit provocative, what I'm going to say, but I hope not too provocative. I really have 2 points to make. One is, which I'll raise second, one is that it's surprising to me that there is no citation in this book, no discussion in these papers of what I consider to be the second most important school segregation case or education case, which is just totally ignored. And that case is Griggs. Thomas was asked during his hearings what were the 2 most important decisions decided during his law school career, and I think he may have misunderstood and thought it was since he was in law school, but his answer would have been right either way. And his answer was Roe v. Wade, and Griggs. And then he was excoriated for referring to this obscure case called Griggs. So I had a research done to figure out what were the 2 top topics of questions directed at him by the Democrats during the hearings. And guess what? The answer was Roe v. Wade and Griggs. So Griggs is an important case. Griggs, in my view, and I'll get to this in a minute, essentially overrules Brown. Is that provocative enough, Paul? On the question of expertise, I think that in the administrative state and who's going to be telling us what to do, and I think that is now undergoing a lot of change and a lot of ferment in the courts, and I think that was a big part of the nomination of Justice Gorsuch. He had written probably more than any other sort of applicant, if you will, about the question of Chevron deference and the question, the predecessor question of unbounded discretion, of giving the courts too much leeway, of making it too easy for the agencies to make it up and utilize their expertise. And I think Justice Thomas thinks that there is no authority at all to make up rules. He tells the story, Thomas does, of one session, I guess, that involved a Supreme Court argument involving Chevron and Our is the deference to a rule of interpreting a rule of an agency as opposed to a rule of Congress. And it's the way Thomas tells it. Justice Scalia leans over to him and says, you know, that Our decision, that may have been the worst decision ever rendered by the Supreme Court. And Justice Thomas says, you know, I have a feel for that. You wrote it, Nino. So I think he was changing his mind. Non-delegation was coming back. He had written an earlier opinion in 2000 saying that if there is an issue of non-delegation, that is over-broad, over-vague delegation from Congress, which provides no guidance for either the agency or the courts to judge, then it's the court's job to interpret what the statute is supposed to mean, not the agency. So since the two are so connected, there is one great big exception to Chevron, which has been, I think, kind of ignored. Towards the end, there's one case involving CO2, climate change. It's called, I don't know what the name of the case is colloquially, but it's has to do with changing the thresholds to make the statutory scheme easier to implement, and the EPA says, well, you know, 250 tons really means 100,000 tons. And that's where we're going to start, at 100,000. And we will try to work our way down to 250, but we'll start at 100,000. And that was a little bit too much for Scalia, who had one of his great lines, I think: we're not going to sit idly by on the dock and wave goodbye to EPA as it embarks on its voyage of discovery. So I think that he was beginning to question these delegations of authority or assertions of broad delegation, the discovery of ambiguity everywhere. And I think we'll see much more about this under the next Supreme Court set of rulings with Gorsuch now there. The other issue I wanted to discuss, of course, is Griggs. Griggs said that it's a disparate impact case. It's where all the disparate impact issues come from. Griggs said that you couldn't use a college or a high school diploma as a screening method for hiring because blacks graduated at so much lower level, got diplomas at a much slower rate, that you would automatically have discrimination. And so there ensued, a dozen cases and many rules out of the EEOC, all very confusing and all very difficult to follow and all very very troublesome about what really is disparate treatment and what really is disparate impact, and how much should be attributed to disparate impact. And the way it was administered by the EEOC was through a practice called race norming, where you take each ethnic group, Hispanic, Black, Caucasian, Asian American, whatever, and you rank them inside their own silos. And then you pick, for admission, if you will, the top 10% of each group, and that's how you get a perfect reflection of the population in the marketplace. When the 1991 Civil Rights Act came along to try to overrule a Supreme Court case that really cut back on Griggs, the Congress also outlawed this practice of race norming. Now, it comes to sort of a head, this whole question comes to a head in a case which has gotten virtually no attention called Ritchie versus Di Stefano, which is the New England firefighters case of just a few years ago, and whether the New Haven Fire Department, could use teaching materials developed by a supposed independent test producer to be used for both written and oral applications in the ranking of the applicants for the job. And the Supreme Court it was a very lengthy opinion, as you can see. It just it's about as long as they get. The interesting thing is they say, well, the statutes require both application of disparate impact and disparate treatment. And Scalia raises the question, and the question's raised in the majority opinion. Well, if you're trying to correct disparate impact, you have to use disparate treatment. And how can you reconcile those two? Well, the court manages to do it with some great gymnastics. I had to read the gymnastics 2 or 3 times over the last few days to really understand the virtuosity of Kennedy's opinion. But Scalia doesn't really let him off the hook, and I think this is where he ends up on the whole question of what Brown means and how it's to be applied, not just in the context of school busing or even higher education admission, but the use of education broadly as a method for screening for job opportunity. We think, for example, of Germany's practice of having employers in local areas really take over, not completely, but almost take over the instruction at, or what should be instructed at the local community college or high school. They tell the teachers there what they need to have, and I can assure you when they hire, they hire by performance, by how well the students has performed in terms of the learning of the curriculum that they have devised. You could not, at least until the Ritchie case came out, you could not, if you were an employer, not for law schools, we get exempt, we lawyers get exempt. I think
the military as well.
And the military is exempt, and military is quite exempt. But if you're a general employer, you could not ask. Not only could you not ask for the transcript of the student in the high school, you couldn't even ask for evidence of a diploma. Now that's pretty rugged. Now the U.S. government does get a pass on that. So the Army and the Navy and the Marine Corps and the Air Force and whatnot have all used a graduate level diploma or equivalent as a screen for admission, if you will, for recruitment. And it's interesting to see that minorities end up in a much higher percentage in the military than they do in the working population at large, and or their own percentage of the population at large. I'll just, since my time is up, just simply quote from Scalia's last, and this is a very short, blessedly short Scalia opinion. It's one of the shortest he ever wrote, I think. It's 4 pages. So it's easily absorbed. The court's resolution of these cases makes it unnecessary to resolve these matters today. That is, how do you reconcile disparate treatment with disparate impact? But the war between disparate impact and equal protection will be waged sooner or later, and it behooves us to begin thinking about how and on what terms to make peace between them. And I don't think we've really come to grips with this yet. I don't know what cases are getting up there to come to grips with this. The Ricky case, Ricky, what I pronounce it, sort of put to rest many of the questions people had that were bouncing around in the courts between the time of Griggs and the time that the Supreme Court case that cut back on Griggs was decided, and then the 1991 Civil Rights Act came up as a response. It lays to rest much of this, but the whole question of quotas and whatnot is still not ultimately resolved. I know from reading his concurrence here and some of the other opinions that have been referred to and quoted from, that I think where Scalia would have come out would have been, again, colorblind. You can't use disparate treatment to correct disparate impact. That would violate equal protection. I think that's what his view would be. We don't really know for sure, but I think that is the burning question that has not yet been resolved.
Thank you, Boyden. I think we should give Shep a chance to comment on the Griggs case.
Sure.
Yeah.
Thanks. Couple of points about Griggs, and I think it fits into what I was saying about growing conflict between Justice Scalia's willingness to defer to the judgment of Congress and state legislatures on one hand, and his reading of the Equal Protection Clause on the other. Most of you probably know this, but the Griggs case was written by Chief Justice Berger. And part of the background there was that New Power was a very bad actor. You know, they didn't come with clean hands. They were suspect. But one of the most important things to remember is this was a statutory case, and most of these issues are statutory issues. This was under Title VII of the Civil Rights Act. Many of these other disparate impact cases are under Title VI of the Civil Rights Act. And when the Supreme Court did start cutting back on Griggs in the mid to late 1990s, and Ambassador Gray will remember this very well since he was right in the middle of the congressional fights about this. Once the court cut back, then Congress said, no, we like the system that we had before. And they came to the defense of the previous, what I would say is quite, the court's rewriting of the Civil Rights Act. And on race norming, they overturned the race norming new practices. But when it came to the burden of proof and disparate impact, basically the Congress said we want to go back to the Griggs et al. Standard, and that left Justice Scalia with, do I defer to what Congress has said, or do I overturn that with my understanding of the Equal Protection Clause? So that was, I think, one of the central dilemmas that justices are going to be facing over the next coming years.
Amy.
Yeah, disparate impact. I've actually written 2 big articles on disparate impact, one in National Affairs, which is a journal of opinion, and one for a law review, so I know the case very well. I would just make a couple of comments about it. And first of all, I commend you for bringing up that case. You're right. It's really an important episode in understanding Justice Scalia's thinking about these matters, and a very important case. First of all, in Griggs, the court did not say that using these educational credential screening devices was absolutely prohibited. They said it was the use could be justified by the employer by showing business necessity Of course, that is a very manipulable standard and a very hard standard to meet. Second point is that this disparate impact device, which I think it is fair to say Justice Scalia has some real issues with, as denoted by his Rickey decision, has spread like kudzu to other areas. So it's been extended to housing under the Fair Housing Act. Any practice, local zoning, or other policy that has a disparate impact on minorities is suspect now. It's been extended to school discipline through Dear Colleague letters and rulemaking by the Department of Education. If a disciplinary practice in public schools has a disparate impact on minority students, it is suspect. So we do have the proliferation of these policies, and I think, you know, that bears contemplation. If Scalia were with us today, I do wonder whether he would sort of redouble his critique and reminding us that, in fact, to implement these policies, we do need to be race conscious in ways that might run afoul of the Constitution.
I just want to comment on the other topic that Boyden Gray brought up, and that is Scalia's thinking on delegation of Congress to agencies. I think it's important to understand that Scalia was originally very concerned about congressional committees writing their preferences into law by writing a fairly vague statute and then having committee hearings and committee reports that went into much more detail and were written by advocates for some noble cause or another. And then the courts would come along and they would use these committee reports as the text to interpret the statute, even when the administrative agency didn't interpret the statute in that way. So he was inclined to say, okay, let's go with the text of the statute, and then if you're going to have interpretations of the text, you should have the administrative agency's interpretation count as decisive, not some committee report that the whole Congress never saw or never considered. So I think, you know, the issue evolves and becomes a situation where that's no longer the problem. A new problem arises, but some of the language that he had used to address the initial problem, you know, gets in the way of solving the new problem. So, Ambassador, what's your reaction to those comments we've all had?
This could get into a law school class debate. With our first speaker. I don't think I was involved, so I'm biased. You have to take that into account. I don't think what the court, what the Congress did was reverse Ward's Cove and go back to Griggs. The minority opinion, and Rickey tries to sort of say that that's what they did, and there are a lot of terms that are used in these various cases: manifest relationship, job related. What do they mean? And but manifest relationship was not the standard used, and the way it was solved, the way it was resolved in the back rooms just before it went to the floor in 1991, whenever it was to use the business necessity language that was adopted in the Americans with Disability Act, which was not a quota bill. I mean, has never been even thought to come close to being a quota bill or a disparate impact bill, let alone a disparate treatment bill, or not disparate treatment, disparate impact. And the language from the ADA does not revert back to Griggs and its progeny up to the Ward's Cove decision that reversed much of this progeny. Now, we can get a big argument about this, except all I can say is that Ginsburg, in her dissent, pretty strong dissent, in Ricky goes on forever, just like the majority opinion. She tries to cite the 91 Act as support for her position, but she lost 5-4. So I don't know. On the question of deference, it is true that Justice Scalia did not like committee reports. He did not really like floor statements, because often floor statements, of course, were written by people like me and inserted by the reporter as actually having been delivered on the floor when the speaker probably was somewhere in Timbuktu. So he was right to be skeptical of all that, and he knew all about that. But people did in those days really care. In those days, the early days when I first started practicing law, people really did care about the actual language of what was being worked out in subcommittee and committee. Forget the reports, forget the floor statements. And there were food fights, and the parliamentarians were called in to rule on the validity of this amendment or that amendment. How many people here have heard of an amendment to the third degree? You see, one hand goes up. But that was, God, you couldn't get through it was actually great theater to go to a markup session and watch the food being fought over whether or not an amendment could be used to amend an amendment that was being used to amend an amendment. It was being used to amend the statute or whatever. I mean, so people really, really, really ground out every single word of the text. And I can assure you, from my experience with the Environment and the Clean Air Act, that John Dingell never would have given any discretion to EPA if he could possibly avoid it. He gave EPA the number that they had to use, the grams per mile. It wasn't in your expertise, dream up a grams per mile. And he said, no, it's that's what it is, and live with it. You I won't finish the expletive. So I do think Congress started getting away. Part of it's the 3-day work week. It's kind of hard to have deep markup sessions when you're, and then campaign finance laws. They spend most of their time across the street raising money, and every single campaign finance improvement has worsened my balance sheet. 30 years ago, there was a limit, it was a cap, $30,000, something like that. I could say I'm maxed out. Now you can't say you're maxed out. I mean, there's no limit to how much I can give. So much for reform.
I think it's time for us to open up the audience. You want one more response?
Yeah.
Okay.
Just one quick thing about the Civil Rights Act of 1991. I'm actually not going to. Ambassador Gray was in those back rooms. I wasn't, so he knows what's in there better. But one of the interesting things that links the question of legislative history to that act was, and correct me if I get some of the details wrong. The meaning of the act was so unclear that everyone was trying to get in their understanding of the legislative history. And I believe that Senator Danforth got up and said, one thing we've agreed on here, this is part of the compromise, is that there will be no legislative history. And that we've all agreed that we're not going to engage in this game. And immediately Senator Kennedy and others got up and said, well, what Senator Danforth meant by that was X, Y, and Z. So I think one of Justice Scalia's greatest accomplishments was to reduce significantly the frequency at which courts looked at this. And there's a famous incident on the floor of the House where someone starts trying to say, why don't we just do this through legislative history rather than amending the statute? And Barney Frank said, I will answer that in 2 words, Antonin Scalia.
Yeah, can I say one thing about this? My students, I teach a big civil procedure class every year, and I am struck by my students' very crude ideas about Justice Scalia, that he's some kind of demonic figure that stands for, all the wrong things. But what I do say to them is Scalia has been a very salutary influence in disciplining judges to look at the actual wording of statutes and carefully consider them. He sort of sternly stood over them and insisted that they do that. And I think the propensity to do that, if you go back in time to older cases, was severely lacking. So I think the students see that trajectory towards more discipline and attention to the actual wording of legislative enactments. That's partly Scalia's doing.
Okay, so I'm sure this conversation has stimulated thought in the audience. Yes. Just wait now. We're going to give you, hopefully, a working mic.
A few weeks ago, a group of Asian American students sued Harvard University's admissions procedure for discriminating against them, and one of the statistics they used was the enormous spread between Asian American SATs for accepted students at Harvard and black SATs. I have a personal interest here. I'm a Harvard graduate, and I've agreed to interview applicants this coming fall. I'll be meeting with a few fairly soon. And so if I happen to have any Asian American students, I hope the panel will give me some guidance as to what I'm supposed to tell them about Harvard's admissions policies.
Can I say something about this? I just wrote an article about this. It's called On Not Dreaming of Affirmative Action. It's a couple of years old, but I think one important point that cannot be forgotten is that private institutions can do pretty much what they want. Now, there is Title VI. There are some sort of legislative limits potentially, but affirmative action has not really been litigated on that basis. It's been litigated as a constitutional principle, and all the big cases have involved public universities. Okay, that's a really important thing to remember. For better or worse, Harvard has pretty much a free hand in discriminating against who they want to or whatever standards they want to use for admissions. Now, as I tell my children, the fact that you have a right to do something doesn't make it the right thing to do. So I think that the discussion needs to take place on the plane not of what is legally permissible, although once again, under statutory materials that might be debatable. It's, what should Harvard be doing? How should they be choosing elites? This is a long-standing issue, and it's not an easy one. So I would maybe say that to them.
Yes, unfortunately, Harvard got the great honor of being referred to in the Bakke case as doing the right thing, that they had a diversity policy, and I think Amy's right, that they were irrelevant in that case because they were a private institution. Whatever they were doing was their business, and wasn't sort of appropriate for consideration. But Mr. Powell found that as the way to solve a problem that he had. Yeah.
Hi, Mark Walsh. I cover the Supreme Court for Education Week and some other publications, and I had a question that, like Ambassador Gray, I looked at the essays and I was looking, I think in vain, unless I missed it, for a discussion of a kind of a provocative issue that Justice Scalia wrote about in one case, in Troxel versus Granville, a case about visitation rights, and often spoke about in speeches, and that was his belief that there was no fundamental right or no substantive due process right for parents to direct the upbringing of their children, which include education. That goes back to cases in the 1920s. But I was going to read one just from the Georgetown Law appearance. I'm not checking my email here, but just this Troxel opinion gives it a little more clear. But he said, such a parental right is simply not in the Constitution. I will not enforce it from the bench. And I just wondered if you might be able to comment on that, since I didn't see it in the essays at all.
Yeah. Shep?
Take a first crack at this. One of the big disputes within conservative jurisprudence is whether there are rights that are not enumerated that should be respected. And there obviously is a big difference between Justice Thomas, who basically says we need to look at the Declaration of Independence. And that says that there are natural rights that might not be listed explicitly in the Constitution, and that would seem to be a good candidate for these natural rights. Justice Scalia was obviously extremely reluctant to do that, that he wanted to look at the Constitution and not talk about the spirit of the Constitution or the driving force behind the Constitution. I think in the long run, that position, which in some ways becomes more positivistic, probably is not going to prevail. But on the other hand, I must say I have significant respect for Justice Scalia's skepticism, and I think this goes to Amy's point about skepticism of experts, that that judges on the Supreme Court are particularly adept at identifying what those fundamental rights are.
I think that's just a wonderful case to bring up because it really focuses us on this debate about substantive due process, where Scalia really is averse to the recognition of any unenumerated rights in the Constitution. But what it also shows, this issue of the rights of grandparents versus parents, is that substantive due process, or rather a repudiation of it, cuts both ways. It's sometimes or refusing to recognize these natural rights that are incorporated into the Constitution, very difficult issue, sometimes gives the legislature a free hand to do things which a traditionalist and a conservative really would dislike, right? Give grandparents visitation rights and derogation of parental authority. And I think that Scalia was sometimes willing to bite the bullet on that stuff.
My question stems from the last exchange and from some earlier comments that Professor Melnick made. I think you said it's fair to say that Justice Scalia would have voted to uphold Brown if anybody had ever challenged it. But there was a companion case to Brown, Bowling versus Sharp, and that question involved whether the federal government, as to which the Equal Protection Clause does not apply, should be subject to the same limitations that the court was adopting in Brown. And the Supreme Court said yes. So, if that issue came up before Justice Scalia, what do you think his response would have been then?
Would have been then, or would have been 20 or 30 years later? What actually, I think Justice Scalia would have said, what we apply to the states, we should apply to the federal government. Yes, the argument that somehow due process is the same thing as equal protection is a pretty hard logical case to make. And I guess I would just make this general point, that being a judge requires statesmanship, not simply logic. We see that best, I think, in Chief Justice Marshall. This has become such an embedded part of our political understanding, and for extremely good reason, that there is no reason to look back at that, to reconsider it, but better to say how should we interpret that basic commitment to racial equality as expressed in the view of the court, which is that that racial classifications are inherently suspect, and that should apply to the federal government as well as the states.
I'm Heather Gradison, and having chaired an independent regulatory agency, I can speak to the point of using committee language, which often we would have commissioners determine the outcome of a case based on the committee language. And we would often argue of whether or not we should use that language or refer to the language to find an appropriate outcome. So there it is, and then it'd go to the courts, and the courts would say inconsistently, you can use it, and then they'd say, no, you can't use it, and that's all I have to say.
I'd say one thing. We're dealing with that problem right now because now we have major legislation without any committee reports.
Right. Yeah, I was going to say, I think Scalia clearly has had an effect. There's less citation to committee reports. There are fewer committee reports. Whether that's a better circumstance is left for us to judge, because the fact is the courts still have to interpret the language of these statutes. They still have to figure out what they mean. And Scalia, I think, at times oversimplifies that task. I mean, there is ambiguity. When push comes to shove, he's willing to admit that. So sometimes there is no clear single meaning.
I wanted to follow up on a comment by Mr. Melnick. I had recently, coincidentally, read an article by former Judge Connell, Michael Connell, who was a litigant, the losing side of City of Bernie case. And he was questioning about how the Supreme Court was taking a too broad look at their role in interpreting the 14th Amendment, because the 14th Amendment specifically said Congress shall have the right to enforce this. And Mr. McConnell went into detail as to how it was argued, and this is in the specter of Dred Scott decision, that Congress specifically did not want the court to get involved in interpreting that, and he felt that the City of Bernie was an effort by the Supreme Court, notwithstanding the clear understanding of Congress when they passed the 14th Amendment, not to be so heavily involved in interpreting, having a role in how Congress utilized that power. So I wanted to ask if there's any comments on that.
I'll take a quick first take at this. Actually, in my class 2 days ago, I was requiring my students to read the 13th, 14th, and 15th Amendment, and notice that there's that final section that says Congress shall have power to enforce this, which most people don't realize. But then what happens when the court's interpretation conflicts with Congress's interpretation, as it did with REFRA, culminating in the City of Bernie? And what I would say in part about this is, as frequently the case in American politics, the separation of powers question about the court versus Congress gets intertwined in a very complicated way with federalism questions. To what extent can Congress force things on the states? So I think that part of what threw the balance in that case was the court's relatively inconsistent effort to try to revitalize federalism. Professor McConnell is such an expert at this, I can't go too much beyond that, although I think I probably disagree with him about my view of accommodations. But I'll just leave it at that.
Boyden, do you have a comment on that? No? Amy? No?
I don't, I have much to say, and I think this is a really hard issue, these border skirmishes between Congress's authority versus the court's authority, and especially in light of the express language here of the power to enforce. I mean, these issues have been ongoing forever. They're very abstruse on some level. I don't know, I don't know the jurisprudence in the sense of what Scalia would say about it, or whether he has a fully developed theory about it. I guess all I would say is I consider this issue very hard.
Any other questions? If not, do the panelists have some final observations that they want to make? If not, thank you all for coming. Please feel free to purchase Scalia's Constitution, Essays in Law and Education, which Paul Gray McMillan has just published. And also join us for lunch, which is available to everyone before you leave. So thank you very much.